Good afternoon, everyone here. On behalf of Symbiosis Centre for Distance Learning and the Institution Innovation Council, that is IIC, I, Dr. Sunita Nikam, delighted to welcome you all to this highly anticipated workshop on intellectual property rights and IP management for startups. Today, we are also celebrating World Intellectual Property Day, making this session even more special. This global compliance highlights the importance of intellectual property in encouraging innovation and creativity, and we are thrilled to honor it with this insightful event. Our session today is designed to provide you with a comprehensive understanding of critical role that IPR plays in the world of startup. From IP protection to patenting, copyright, and trademarks, this workshop aims to equip you with the knowledge and tools necessary to navigate the complex landscape of intellectual property. We are honored to introduce Dr. Shailesh Kedia. I request participants to mute yourself. I request everyone to mute yourself.
मेरे पे वो नहीं हो रहा अनम्यूट
Thank you. We are honored to introduce Dr. Shailesh Kedia, a distinguished academic professional and a thought leader with an extensive background in logistics, supply chain management, and intellectual property rights. Dr. Kedia holds a PhD in logistics management and MBA in marketing and finance, and multiple postgraduate degrees in commerce and economics. His comprehensive educational portfolio is completed by over 2 decades of experience in academic and industry. A magnetic orator and skilled networker, Dr. Kedia is renowned for creating attractive learning experiences and fostering valuable collaborations with academicians, industry professionals, and government agencies. His extensive body of work in business management, logistics, supply chain management, and IPR includes the publication of 53 research papers and authorship of 12 books. Additionally, he has filed 15 copyrights, secured 3 international patents, and 4 national patents in innovative technologies related to business management and logistics. Dr. Kedia's expertise extends to delivering over 50 management development programs, corporate trainings, and faculty development programs. He has also provided consultancy services to prominent corporations and government bodies, addressing critical business challenges and developing strategic solutions. Currently serving as Associate Professor and Program Director for short-term courses in intellectual property rights at Symbiosis Skills and Professional University, Pune. Dr. Kedia continues to drive academic excellence and innovation. He also serves as an editor for 4 international journals, contributing to advancement of knowledge in his area of expertise. His professional profile stands as a testament to his unwavering dedication to excellence and his substantial contributions to business management education, research, and consultancy. Please let me join in welcoming Dr. Shailesh Kedia, and the virtual stage is yours, sir. All participants are requested to ask questions at the end of the sessions. Sir?
Thank you, ma'am. Thank you so much, Sunita, ma'am. And I'm sure this will be interactive session and we will be learning something. Okay. So, ma'am, if you can please allow me to share my PPT.
Yes, sir, I'll do that.
Okay, so participants, as I came to know that most of you are from industry, and in industry, everything runs around profit. Everything runs around sales. So what we will do, we will learn IPR, intellectual property rights, considering that these IPRs should be beneficial to us when we are doing business. either as an employee or as an employer. Okay. Now, let me be very clear. We'll make this session interactive so that we can learn something and we can imbibe those things in practices. So let us begin. Now, guys, you must have learned about, you must have visited some malls and gone to movies. While I'll be asking you questions, there will be option for you to answer that question in chat box. I recently visited a mall. There was a very nice movie, Marathi movie, and I wanted to see that movie. The movie name was Juna Furniture. Wonderful movie. But what I observed when I went in the mall and I went in that theater, and when there was a break, halftime break, I came out and I wanted to have a glass of water. I could not find any water facility over there. So there were some counters. I requested them ki I need 1 liter water bottle. And I was ready to put my 20 rupees bill. So suddenly he said ki sir, only 70 rupees. I said, what? He said, sir, 70 rupees. मैंने कहा यार, but water bottle comes in 20 rupees and it is available just outside this mall. Why are you selling at 70 rupees at a premium price? He said, sir, you can look at the MRP, it is 70 rupees. So I said, ki, no problem, I'll go outside and what I'll do, I'll bring that bottle in 20 rupees. I don't want to pay 50 rupees extra. So he responded, sir, if you go outside of this arena, you'll not be allowed to re-enter. This is sheer cheating. I came to see a movie, I paid a premium price for the ticket, and now you're charging me 70 rupees for 1 liter water bottle. Have you faced this situation? And my simple question to you, what do you think? Why they are selling this water bottle at 70 rupees and why people are purchasing in 70 rupees? You can respond in chat box. I'm giving you 30 seconds to think about it and type the response. Why these people are selling that water bottle at 70 rupees? And to my utter surprise, there were people who were buying it, and at the end, I had to buy. The question is why? Last 10 seconds. Hi, sir. This is situation of necessity of the customer in the mall, said by Bala Subramaniam. Okay. They are more by selling popcorns, they need cover up on their expenses due to graphic design and quality. Okay. Prathamesh Deshpande said, okay. To get extra profit, but we don't purchase it. Manufacturer decides the price. Okay. Great. Dhirendra Kashyap said manufacturer decides the price. Okay. Okay. But don't you feel, guys, that selling a bottle which is worth rupees 20, rupees 70, charging 50 rupees premium price, there must be something? Say, given an option that I was allowed to visit outside, uh, Deva Jyoti Banerjee is saying status. Scarcity increases the price. Okay, great. Scarcity increases the price. Okay, great, great. Now, had I been having that option that I could go outside and buy that bottle from outside the mall, so I would have gone and purchased it. But then, yes, Simran, I understand. They have rights to sell the commodity in their premises. Till the bottle reaches the mall or theater, the price hikes at this level, VAT, tax, etc. No, there is no such thing that in mall government is charging extraordinary taxes, or it is also not the case that the water available in the mall is having extra superior quality, so that I need to pay the premium of 50 rupees. But there is one thing. I had to be there in the movie theater for around 3 hours. And being a human being, I used to have, or I need to have, some water intake to keep me hydrated. And in that vicinity, in that premises, they had kept that rule that once you go out, you cannot come in. That means they were having monopoly in that area, that if anybody would like to purchase anything, they have to purchase from them only within that area. They were charging premium only because they were having monopoly. Now, you'll be surprised to know that why I'm using monopoly word frequently. The reason is very clear. Guys, you can charge premium prices, you can have premium profit once you have monopoly in the market. That means only you are able to sell that product or services, nobody else can sell that services or product. Now, what IPR does? IPR creates monopoly for you. IPR creates monopoly for you so that you can sell your product at premium price, so that you can sell your product in such a way that it generates maximum sales for you and you are benefited out of it. So with this, I, Dr. Shailesh Kedia, would like to start this session. As ma'am said, I started my journey as academician. Having business background, dad used to have a shop, and we used to work. And letterwords, I found that in India, most of the mid businesses, they fail to grow because they do not have any monopoly. They do not understand the value of their intellectual property. That was the time I started and have got 3 international patents and 4 Indian patents in my name right now. And 2 of them, they are into commercialization. So let's see what we will be looking, or what we'll be gaining from this session. So first of all, we will be understanding what are the intellectual property rights, various types of intellectual property rights, their role and importance for startups, and what should be the IPR management strategy for a startup. And remember in mind, all these things we are learning so that we can implement. Okay, so something which you will be able to implement, and something you will be able to just remember. But yes, it will be useful if you want to secure a monopoly in the market. Now, as I said, these things will be there. So now, why IPR started? Why IPR started? Big question. So, have you ever heard from your grandpa or grandma or somewhere that in India there was a time when there were kind of people who used to make shawl which could fit in a matchbox? A shawl, big shawl, let's say 2-meter shawl, and you can fold it and you can fix it in a matchbox. Such a smart material, such a handiwork, such a brilliant technique which we Indians used to have. Have you heard about it? Type yes or no. Again, 10 seconds. Yes or no.
Yes, sir.
Okay. Yes. So Priyanka Singh, Hemchandra Upadhyay, and others, they are saying yes, they have heard about it. Now, do you find any such shawl? Yes, Simran Devjyoti Banerjee, I understood. You have heard about it. Okay, great. Now, do you find such kind of item, such kind of shawl in the market nowadays? Anywhere on Amazon, Flipkart, or in the bricks and mortar store which is available near your shop or near your home. Do you find that kind of a thing? No, sir. No, sir. No, sir. Rarely. No. Rarely. I have not seen. Even I tried myself multiple times that such kind of a shawl should be available and we should be able to use that. But the thing is not available. You know, when I did the research, I found out that that technique was not recorded anywhere. The person in the year 1600, when he found out this skill, he used that skill to make shawls. Then he passed on that skill to his son, from his son to his son, his son to his son, and generation to generation, that skill was passed on. Nitu, can you please mute yourself? Nitu Chawla, can you please mute yourself, please?
Dr. Shailesh, you have rights to mute her.
Okay. Okay. So, thank you, ma'am. So, what happened? The day came when in 1950s or 1960s, the latest son realizes that by making the shawl, he cannot earn properly. So what happened then? He stopped making the shawl. He went to Shahar city and started doing some kind of a job which could give him some amount of money for a decent living. But what happened? What happened to that skill? Did he share with somebody? No. The question is why? Why didn't they share that skill with somebody? Of course, the answer is very simple. They were having fear that if somebody will learn that skill, they will start making shawl and their business, that means the originator's business, will die. They were not sure that whether they could sustain the competition. So now the thing is, IPR practices or IPR laws came into existence because the world wanted to protect such kind of a skill which are rare, which are good for human being, and which can make differences in the lives of people. So those who are innovating something new, either product or process or design or kind of a plant or kind of a code, they should be given certain advantage for some time. Let's say if you have patented some new device, so you can utilize that patent exclusively, or you can give the license of that patent to n number of users by charging them some royalties for next 20 years. But what world receives? After 20 years, that technology will be known to entire world and entire world will be benefited out of it. So that was the history because of which the IPR practices started in this world. Okay. Can you guess this movie? Anyone? Just a minute. I think, yeah. Okay. Last 5 seconds. Three Idiots, Three Idiots, Three Idiots. Very good, very good. Neetu, Anandita, Sangeeta. My screen is moving very fast, so I'll not be able to recall all the names. Yes. So the movie is Three Idiot. Yes, Nayan Krishnani said controversy was clash with Chetan Bhagat. Yes. So one of the top movie in Indian cinema, that movie is known as Three Idiot. है ना? So what happened? The movie got big hit, and suddenly one author known as Chetan Bhagat, the writer of 5 point something, 2 states. He came and he said that the movie is based on his work. The novel or the book he has written, this movie is based on that, and he has not received sufficient credit and money for it. The controversy erupted, and Chetan Bhagat filed for a lawsuit. And you know what happened? After some time, Chetan Bhagat and movie maker, they sat together. They finalized one mutual deal, and the case was withdrawn. Some rumor says he received, that means Chetan Bhagat received proper credit for his work. I think in monetary terms and in non-monetary terms also. So the question arises, why Chetan Bhagat received the credit? Because it was his work, it was copyrighted. If there was a court case in the court of law, the court would have said, this is the intellectual property of Chetan Bhagat. How can you use it without acknowledging him, without taking prior permission from him? And if he wants to sell his permission, he has all the rights because he has got copyright of it. So, understood the magic of IPR. Okay, so now enough. So, we talked about IPR a lot of time. What is actually IPR? So, let us see. Okay, so look at here. What is intellectual property? Intellectual property means a kind of property which is created by human intelligence. So, if I'll ask you, ma'am and sir, please let me know that what do you understand by property? Can you name few property? So your answer will be, yes, sir. I have got a home. It is property. Yes, correct. I got jewelry. I got a smartphone. I got a car. I got two-wheeler. And all these are property. But how do you know that it is your property? How do you know that the home in which you are living, for which you have paid handsome amount, it is your property? Because you have registered that property. You have registered that property with registrar office, property registrar office. And there is a law which protects your rights on that property because you have purchased it. You have received the rights. So if you purchase some tangible product in a legal way by fulfilling all documentation, so it becomes your property. So now what about, let's say for example, one of you think that the water bottle which we normally use for drinking the water, it can be in different shape, and that shape can create a lot of utility and a lot of value addition for the customer. So you spend your day and night around 6 months, you created different designs, and finally you come up with one specific design which can solve a lot of problem of human being. And now you want to create bottle, or you want somebody to come up and purchase that design from you and create or make or manufacture the water bottles. How will this be possible? Suppose there is no copyright law, there is no IPR laws, and you share that thing with somebody. Hey buddy, I have created one smart design for water bottles which can solve XYZ problems of human being. What should I do? He'll say, okay, don't worry. Can you show me the design? You show him the design. And next day, you'll be surprised to hear that that fellow has organized one press conference stating that he has created one unique design for water bottle. And that design is exactly the same which you have shown to him. So guys, your intellectual property, the property which you have created using intellect, should be protected, na? Correct? So what is intellectual property? all properties which you create by using your intellect. That is called intellectual property. So, what is intellectual property rights then? Very simple. If you have created any intellectual property and you get the rights to use it exclusively, to sell it exclusively, or to license it exclusively, that rights are known as intellectual property rights. So the question comes, who gives, who receives? So receiver is a person who has basically created it, whose brain has worked hard for creating that design, product, or process. He is the receiver of intellectual property rights. And who gives? Government gives. There are a lot of offices of government which provides intellectual property. But as you know, that physical properties are of different type. Mobile phones, my car, my two-wheeler, my clothes, and so on and so forth. So the same way, intellectual property rights are also of various types, which we are going to see today. Okay, so for each type of intellectual property rights, we have got different government office. What we need to do? We need to approach them. We need to file the application. And once this application is properly processed by them and thoroughly checked, they will give you a certificate that yes, this invention or this innovation is done by you. You have got exclusive rights to use that property. So the moment that certificate is there with you, you can call it your intellectual property. Get it? Okay. So now why this is important in short, I have created one specific slide for it. But why it is important? Encouraging innovation, protecting investment, enhancing competitiveness, and promoting economic growth. Now, just have a brief look of various types of intellectual property rights. Are they exhaustive? No. But yes, these are the main types of intellectual property rights which are used by 99% of the world. Top four which are used by the industry across the globe. Number one is patent, number two, trademark, number three, copyright, then four, trade secrets. These are the top four things which are being used by top industries. You will not be believing that the top industries available in this globe, they have got more than 50,000 patents with them. More than 50,000 patents. Can you imagine? But that is why these companies are successful. We will see some figures also, afterwards. And then there are some other intellectual property rights like industrial design, like geographical indications, then plant variety protection, semiconductor chip protection, database rights, and utility models. Now, if you have got, if you are having this session on mobile or on laptop, take the screenshot of this compiled work. The laws which are available in India, they are written documents and they are available online. If after this session you are encouraged to file for copyright, patent, trademark, or any other thing, you need to visit them. And this slide contains their web addresses and detailed PDF which can tell you how you can proceed. It contains patent laws, trademark laws, and you can see these laws are made in some year and they are amended, not frequently, but yes, they have been amended. Okay. Now, what is the importance of IPR protection in India? Look at the larger picture first, and then we will come to the startup scenario. Now, how do you promote innovation? If India wants to promote innovation, India wants to become the 5 trillion economy, they need innovation. Innovation in manufacturing, innovation in processes, innovation in design, innovation in all the areas where India can save the cost and India can manufacture in bulk quantity. If you look at India last few years, you'll find lot of startups have become unicorns. Unicorns are those companies which are valued at $1 billion. I'm proud to say that we have got more than 100 unicorns in India right now. Okay. Now, how did they become unicorn? They simply converted one idea into either process or product and then got IPR for that. And then they converted that IPR into a into a business or into a license, and then they start selling it. So if you want to promote innovation, what you need to do, you need to assure innovator that yes, your innovation will be protected. We will take care of that. Then protecting investment. Guys, while you are innovating something or inventing something, it requires huge cost. When COVID-19 was there, India produced a vaccine. So one of the company in Pune, they produced the vaccine. So was it a task of a day or two? Did they spend thousand or lakh? No, they spent more than 100 crores. They spent their one precious year, more than that, to bring that vaccine. And suppose after doing all that R&D for a year and after spending more than hundreds of crore, somebody stole that formula of making the vaccine and start selling in the market. What will happen to that company? The company will lose all its investment because they will be pricing that product, vaccine product, after considering their initial investment for research and development. Whereas the party or the person who will stole them or who has stolen them, what will happen to him? He has not invested a single rupee in R&D. So that person will be having ready-made formula and he'll be able to sell that product at a cheaper rate, cheapest price. So protecting investment, another task. Then boosting economic growth. Economic growth boosting means our GDP must grow. How will GDP grow? When we'll be starting more exports, when we'll be producing more, when we'll be producing the products at cheaper rate with better quality. And is it possible without innovation? The answer is no. So it boosts economic growth. Then it preserves culture and tradition. There is one IPR which is known as geographical indication. So what is geographical indication in a nutshell? Let's say, for example, Nagpur, one of the city in Maharashtra, it is known for oranges. So Nagpurian oranges are protected under IPR, which is known as geographical indications. So by this, we can protect or preserve our culture and tradition. Now coming to the big thing. So what is the importance of intellectual property rights for startups? Number one, it gives you competitive advantage. As I said, when you create monopoly, you get more profit. How it happens? So monopoly is a condition where there is only one seller, a large number of buyers. So remember that example of a movie theater in the mall? There was only one seller of water bottle and there were large number of buyers. So he was able to charge the premium price to us. If you want that competitive advantage, you need to go for IPR. You need to do some innovation, invention, and protect it under IPR. Second importance, valuation and funding. If any firm, any startup firm would like to build its valuation or would like to grow its valuation and would like to seek some funding, what they need to do? They need to create some USP for them, unique selling proposition for them. And what is the better way of creating unique selling proposition than to use IPR for that? Do some innovation, either, again, I'm saying either in process or in product or in design, and then go for it. Though it is not the topic of today's discussion, but I'll give you one brief synopsis that how do you do the innovation? मतलब हम लोग innovation करते कैसे भाई? Everybody is talking about innovation, but our mind says, see, I cannot innovate. See, I cannot innovate.
देखो
No,
अब आपने
guys,
नया तो लेना ही है
you can innovate. You can innovate by simply following the procedure which I am telling you. Okay. What is the procedure? Look at the problem day in and day out when you are moving around. The problem can be there anywhere. It can be there in your house. Let's say your floor is slippery. What can you do? Is there any product which can stop the slippery floor? If there is no such product which can stop it, what you can do, you can create that product, you can think about that product, you can research about that product, how you can make certain product which can make the floor less slippery. If you go to any shop and you find that there is huge queue, can you create a system which can reduce the queue without increasing the cost for that owner? If you can create that system, that is innovation, and you can have patent for that. You can have IPR for that. So any problem which is unsolved till date, and there are plenty, I can tell you there are plenty. India in last year has crossed 1 lakh plus patent mark. So Indians have filed more than 1 lakh patents last year. So it proves we have got tons of unresolved problems, millions of unresolved problems. It is you who need to identify. One of my friend, when I was discussing with him, he said, see, I'm a pessimist. I'm a pessimist. I don't think there can be any innovation. I said, pessimism or pessimist, being pessimist, you can create things, na? See, who created the aircraft? Of course, you will say Wright brothers. But my answer is the optimist. One who thought, yes, it is possible कि इंसान लोहे पे बैठ के हवा में उड़ेगा. High level of optimism. They created it, na? But who created the parachute? The pessimist. He wondered कि अगर ऐसा कभी हुआ कि हवा में एयरक्राफ्ट क्रैश हो गया, what will happen then? What will happen? So whether you're optimistic or pessimistic, just follow the process. Identify the problem which is unsolved. Create a kind of process, design or product which can solve that thing. If you want to know how to create any product, YouTube, ChatGPT, Google Gemini, all these AI and Google and YouTube, they are full of different things. You just give them commands, they'll give you some solutions. Okay, now this process is over. If you believe this, you can do this. From my own experience, I can tell you. In 2007, that was the first time I tried to file one patent. I had one very good idea. As per me, according to me, it was a very good idea. I converted that idea into a process and I went to an attorney कि यार मेरे को patent file करना है. I went to some professors also कि patent file करना है. And everybody discouraged. They said कि management में patent file नहीं होता. Business management do not file patents. I went from attorney to attorney, different attorneys, could not find a proper attorney. So I went to a normal practitioner and it took me 10 years to receive first patent. What I learned, I'll share with you in this session. I learned that if you have got very good idea, if you have converted that idea into process, product or design, you need to find out the right attorney who can convert that idea into a proper draft. Because government system, patent system or IPR system, they works on written draft. You need a proper draft manager, and attorney, proper attorney can do it for you. Okay. See, I'm not the attorney, so I'm not selling myself here. Okay. And third advantage or importance, commercialization and monetization. See, IPR, they are just like any other property. So once you create that IPR or once you get that IPR, what you can do? You can commercialize it. That means you can either give license to someone. Okay, this is my innovation. If you want to produce based on this innovation, you can give me royalty. So let's say, for example, this mobile design is innovated by me and it has been used by Samsung. So I can say that, okay, 2% of your revenue should come to my account as a royalty because the design is been done by me. So yes, this is possible. Another thing what I can do, if I have created a product or a design, I can convert that design into product and can start producing that product by myself. So all these companies, IBM for the namesake, Facebook, Google, they have tons of IPRs with them, and what they're doing, they're using it for themselves only. And in India's scenario, lot of startups, they are going for cross use of IPRs. That means 3 or 4 startups are coming together. They have got IPR in different areas, and they are coming together, sharing each other's IPR with each other and creating a product which can serve to masses or larger population. Okay. The fourth advantage which you will receive once you will be going for intellectual property rights is you can expand your market. You know, there is a biggest threat. I have created something new, it is done by me, it is innovative. What if somebody copies it? Let's say right now I'm selling it in Maharashtra. Right now I'm selling it in India. And suppose tomorrow I want to sell that product in Dubai, in Australia, in European countries. So if somebody copied my idea, what will happen? This fears restricts us to move outside our horizon. Once you have got IPR, you can kill that fear. Okay. See, IPR is not that simple. I'm just giving you basic idea that yes, this can be done. These are the advantages. When you will be going for filing process, there are complications, but yes, have patience and one day you will be rewarded. Okay. Now coming towards the first type of IPR. This first type of IPR is known as copyright. Okay. Indian Copyright Act 1957 governs this thing in India. What can be copyrighted? What do you think what can be copyrighted? You have written any poem, you can copyright that poem. You have written any book, you can copyright that book. You have written some very good process for something, some manufacturing process, some product making, some product design process, you can copyright it. Any kind of new software which you have prepared, you can copyright it. Okay. The question might come in your mind is, sir, see, if somebody has already written some article or poem and he and she has not already got it copyrighted, can we do it in our name? The answer is no. We cannot have IPR for any kind of a thing which is duplicated, which is plagiarized. The similarity should not be there. It should be unique. The first condition of any kind of IPR that it should be unique. The world should come to know about it first time. And that's only or then only that IPR can be processed. Then only that IPR can be processed. Okay. So literary work, any kind of book, article, poem, software. Now you have, let's say, you devoted your some time, 3 year, 4 year to make some painting. You inspired by Picasso, and you created a very good painting. Now you want that this painting should be in your name, and the world should know your name because of this painting. What can you do? You can go for copyright. You can submit that painting to copyright office for copyright. Once you receive the copyright, till you die, and even after your death, till 60 years, it will be in your name. If you want to sell it, yes, you can sell it. You will be getting entire amount. Do you want to give the license to sell this product? Yes, you can give it. What will happen? What will happen? These products will be sold by somebody else and the royalty will be received by you. Okay, so let me be very clear what is royalty, because most of you must be knowing, but maybe some of you might not be. So royalty is a kind of a fees which has been paid by selling person or a company to the original innovator or inventor. So how much royalty is paid? Yes, it is paid as per mutual agreement. So on some product, the royalties are paid 20%. On some product, it is paid 30%. On some product, it is paid only 2% or 1%. It is decided based on mutual agreement. Okay. Now, musical work, if you have composed some very good music, some lyrics, you have written some very good song, and you want to sing it by yourself. You feel you're a very good singer. So if you are singing that song and you want that, it should not be copied by others without your permission. Go for copyright. It is copyrightable. Any audiovisual work, movies, even YouTube movies. If you have created any movies and get it copyrighted and then upload it on YouTube, nobody will be able to hijack that idea. Nobody will be able to use that movie against your wishes. Any kind of sound recording, compilation and derivative work, they all come under copyright. Now, copyright secures your creative work. The kind of creativity which you would like to, which you would like that world should know, it will be there in your name. Okay, so fantastic thing. One question arises in one of the session I recently delivered. Somebody said, "Sir, I have got one idea about one new product. Can I share with you right now in front of all the audience?" I said, "No. The moment you share your idea, it will become public knowledge and anybody can steal it because you don't have the protection." Well, okay. Then second question arises, can we get the IPR for idea? The answer is no. Just idea cannot be copyrighted, patented, or cannot have trademark for it. You need to convert that idea either into product or into process or into kind of a design, kind of a literature, kind of a picture, and then only it can be copyrighted. Okay. So what can be copyrighted? Any musical words, they can be copyrighted. Dramatic words can be copyrighted. Any dance move, you think that you have created a wonderful dance move, it can be copyrighted. Any kind of graphic and graphic related work, they can be copyrighted. And then pictorial work, you have done some research paper, let's say research reports which you have created, and that is unique. It is not plagiarized. That can be copyrighted. And what you can do after that, once this copyrighted work is in your name, you can sell it to the world. You can publish it somewhere and you can mention it. If somebody want to use this work, they need to contact you, give your email ID or phone number. Once people approach you, sell them. Okay. Any kind of motion picture or visual work can be copyrighted. Any kind of architectural work can be copyrighted. Okay. Sound recordings can be copyrighted. Advantage, it is automatic. Very little cost for protection. Only 500 rupees are required to create a copyright. And then limited protection can be an early form of copyright. are the form of IPR, and it has a very lengthy time. Even after your death, 60 years, it will be in your name. So that is another thing. Now, coming down to the second type of IPR, which is the most talked about, and maximum industry in the world, they uses this patent. Okay. Now, taking a break. Any guesses which country tops in patent filing in the world? I'm giving you 30 seconds. Don't use Google, please. India, Israel, America. Okay. India, Israel, America. No, guys. China. Yes. A lot of people are saying China. You're right. In the world right now, China almost hold 46% of patents. Okay. Simran Shaw, your question, sir. I have a question. What if I wrote a poem and before copywriting it, I posted it somewhere where other people can see it? Can I copyright it after posting it? The answer is yes. When you file the copyright application, what Shimran asked, she asked that if she has written a poem and before getting copyright for it, she has posted it on, let's say, social media. So can she get the copyright for it? The answer is yes. How? When you file the copyright, there is one option where you need to tick. The option is, has this work been published or not? If you tick or not, it says that you have not published this work. If you tick, yes, I have published this work, then you need to fill where you have published this work. But technically saying, it is a very bad idea if we want to make copyright of something or we want to get copyright of something, do not post it anywhere, because let's see, for example, somebody copied it and he claimed it that before you posted it and he created the same and you have copied it. So then there will be a big debate, and there is no point in going to that debate. You may win, may lose, but again, it will create a lot of problem for you. Okay, so now moving ahead. What is patent? Patent is a kind of a guarantee that you can use your product fearlessly. Okay, now let's say if you take patent in India, your patented item is protected for 20 years. How many years? 20 years. You can reapply for continuation of patent for 10 more years, and subject to certain conditions, it can be allowed to you. What is important while you're filing for the patent? Number one, your invention should be novel. It should not be non-obvious. It should be non-obvious. If you have created something, let's say a new pencil, if it is obvious, nobody is going to give you the patent. The work you have done, the product, system, process which you have created should be non-obvious, should have some uniqueness, novelty. It should be useful. You need to tell people, you have to tell people, you need to convince the office that this invention is useful for human being. Maybe useful for 10 people, maybe useful for 10 lakh people, or maybe useful for 8.2 billion people available on this earth. But it should be useful for someone. Now, there can be new product, there can be new product processes, or there can be new technological advancement. All these things can be patented. Now, what can be patented is another question. Okay, let it go. Very simple. Product. You understand product. So product means all kind of product. Whether it is a small product, let's say earbuds, This is also a product. Nail cutter, it is also a product. Let's say a bigger product like aircraft, a big ship, 1,000-meter ship, whatever. The product is a product. It can be machine, it can be tool, it can be liquid. If you have created it, it has got novelty, it has got certain use, it can be patented. Any kind of process or any kind of method, either used for manufacturing or used for software, anything. If it is novel and useful, it can be patented. Non-obviousness is the most important thing. If you have created something which is obvious, nobody is going to give you patent. If you have created something which is genuine, which has not been seen by the world till date, and it has created or it can create certain utility in the lives of people, whether small utility or larger utility, all these things will be patented or can be patented. What is the patent process? Now, how do you protect your patent? The simplest thing which we do, we file for patent. Before filing, we go for patent search. There is one useful free tool available on internet which you can use. Which is that free tool? If you have pen and paper, note it down. The free tool which is known as Google Patent Search. Google Patent Search. Let's see. You got some new wristwatch you have prepared. So you want to check whether someone has created this kind of a wristwatch or not. Go to Google Patent, type some keywords like wristwatch, technology, or any other thing, whatever you feel comfortable about your patent, and click on it. Google will show you the relevant results that related to your search keywords, how many patents are there. You can see their synopsis, you can see their details, that what has been done by the world till date. Based on that, you can assess whether your idea or your product is novel or whether someone has already done that thing. If someone has already done that thing and you feel that you can change, you can create some change in that, go for it. If the existing wristwatch is not having certain feature, and if you can add couple of feature or 3 feature, you can go for it. You can go for patenting of the same. Patent is not always the entirely new product. Some amendments in the existing product which are creating more utility can be patented. In 1960s, when first time India saw a toothbrush, it was a straight toothbrush, straight like this. And today we have seen angular and extra bristles and zigzag bristles and whatnot and whatnot. So all these things are the amendments or additions or some value additions to the existing product, and all these things are patented. Getting? Okay. Now, safeguarding your innovative ideas, you need to do simple thing. Number one, Google search. Whatever you have prepared or whatever you have designed, whether it is already available. If it is not, if it is unique, go and file the same thing on Indian Patent Office. But while filing, you need to contact one attorney, or if you are having sufficient knowledge of legal drafting, because legal drafting in case of patent is entirely different. I can tell you, I tried at least 150 times or 200 times. Till date, I can say ki I am novice. I cannot write my own patent. I can explain them. I can explain them like anything. I can sell them like anything. But I cannot write those patent in the legal language. you need an attorney. After hiring one attorney and writing that patent, file it. After filing, you need to wait for a certain period. After a certain period, that IPR office, they used to provide you either acknowledgement, yes, your patent is approved, or they will be having certain queries. Yes, in your patent, we have got certain queries, you need to resolve it. Once you resolve that query, you will be through and the patent will be awarded to you. Okay. And the brilliant thing with patent, it is there for you for 20 years. Okay. And you can reapply for 10 more years. So imagine, instead of doing the regular work which we are doing, if we invent something which creates value, so one little invention or one invention can create fortune for you and for those who are using it. Okay. Now, how many types of patents are there? Number one is provisional patent. Now, this provisional patent is something, let's say, for example, you have got certain idea and you created a new type of a chair on which people can sit. Now, this idea is still raw. You want to make so many amendments to it, but the basic design is there in your mind and you want it to be protected. You want to upgrade that, but you want to protect that design. What can you do? You can go for provisional patent filing. Yes, this is my provisional patent. This is the idea on which I would like to file for final utility patent. Okay. So now, once you apply for provisional patent, and if that is unique, you'll get a protection for 12 months. 12 months. That means for next 12 months, you have got a time in which you can develop that idea into a wonderful product. You can add all the value additions which you wanted to add, and then you can file for the actual patent or the bigger patent, which is known as utility patent. Utility patent, it provides you comprehensive protection. So let's say, for example, if you have taken the patent comprehensive, if you have taken the utility patent in India, so in India, you will be getting comprehensive protection. Nobody can use that product. Let's say you created that wonderful chair and you got it patented in your name. So that chair can be used by you only. Or you can give permission to someone else by charging something or without charging something, and you can make it clear to the world that if they want to use the chair, they have to take your permission. It is a very good opportunity for you to earn handsome amount at the same time, not just for 1-2 years, for 20 years. Utility patents are normally technology driven nowadays. The world has not remained the same after introduction of artificial intelligence, or I should say after the utilization of artificial intelligence. Nowadays, most of the startups, they're working on the technologies like artificial intelligence, machine learning, Internet of Things, blockchain technologies. In all these areas, new innovations are going on every single day. 4 days before, Google launched a few more AIs. Just a week before, ChatGPT has introduced one more latest version of its GPT. So the world is changing. In today's world, if you're thinking about patent, utility patent, use technology and create your patent which is technology driven, because then you will be able to reach to the masses. Third thing, which is known as design patent. Now, what is design patent? Let's say, for example, you don't want to make any product. You have created one design for something, new kind of a laptop, new kind of a vehicle, new kind of a goggle, new kind of a dress. you have created some design or device. So recently, the last patent which I received, it was a warehouse management device. The device is a handy device which you can carry on your hand, and with this device, you can have the complete stock of the inventory in a fraction of a second. Okay, you can move that device anywhere, or you can keep that device hanging somewhere. That will record all your inventories which are coming in your warehouse and which is going out in a warehouse. That device can also send signals and can give you enough idea that where you have kept the inventory, in which shelf the inventory is there. Okay. Now, I don't want to make the product out of it. If I want to make the product out of it, then I can go for utility patent. But I just want to have the design. I have created that design, and a couple of companies have approached me that yes, they would like to explore this thing. So I just created that design. I wrote down all the components which is required to create product. I wrote down all sorts of requirements, all sort of details of that design, so that nobody can steal it or nobody can steal it. Now, that design, it is submitted from 7 sites of photos. So let's say this one device is there. From 7 sites, the design photo has been created and I have submitted it and got the award of it. And top of it, in India, one of the most easy way
ये टॉलरेट मेरे से अप नहीं हो रहा बात तो बताओ
one of the most easiest way to go for patent is design patent. What happens now? You can get design patent in 3 to 4 months. You won't take much more time. In case of utility patent, it takes 3 to 4 years. And if you go for expedite route, it takes 1 to 1.5 year. Okay. So now design patent. If you created design, if you created any design, you can submit it for design patent and you can get it. For design, you get 15 years of protection. So, Neetu ma'am, would you like to say something? Okay, let us continue. Now, when you create a design, just do one thing. Go for Google patent search. Type the keywords in the area where you would like to have the design created by yourself. Go for gap analysis, the kind of design which is not existing and is not in existence, and then create that design. Hire one good attorney. He'll do one thing. He'll create the draft for you, which is unique, and based on that, you'll be able to get design patent. Okay. Now, plant patent. If one of you or some of you are in agriculture and you have created a kind of a plant which is not there in the world right now, you created something, कोई नया type का बीज, कोई नया type का flower, कोई नया type का ornamental plant you have created, you can have patent for that. The question might be arising, ki, sir, but what will we do with that patent? The same thing, you can sell it. You can create the product, you can sell it, or you can simply sell the license and somebody else will create and somebody else will sell it. Normally, for patent, protections are given for 20 years with 10 years of extension, and in some cases, there are 7 years timeline which has been given for patent holders. Patent filing process, as I have already informed you, submit your application. After submission, there will be examination and review by the patent office. They will check. What they will check? Whether there is novelty, whether it is inventive, is it having some kind of value addition for industry or people? If yes, they will give you the patent. They will award you the patent. And the moment you submit the examine, let's say before even thorough examination, they publish the abstract of the patent in the journal, which is published normally twice a month or sometime more than that. If any person in India is having any objection on it, they can raise that objection once it is published in the journal. If there is no objection and in the due course of time of examination, patent office feels that your product is novel. In that case, what you can do, or in that case, what they will do? In that case, they will award you the patent. Now, what are the key considerations? As I have already informed you, it should be novel, non-obvious. Google patent search, use Google patent search. The document which you are submitting, in which technical specifications, technical advantages, and real life application must be there. Again, please ensure that if you have done something new and if it is not covered in one patent, go for 2 patent, 3 patent, 4 patent. But cover it sufficiently and select the patent attorney properly, because that person is one of the most important factor in patents. Okay. So coming down to the next part or next IPR, it is known as trademark. Can you see these 3 logos? I'm giving you 30 seconds to observe these various pictures and these various arrows and words which I have given over there. Any guesses how much time Coca-Cola would have spent on designing this type of bottle? Oh, of course, forget it. How much time is required to decide name or brand name of your product? If any one of you, if you have done anything in this area, can you share your thing? How much time you required in past to identify one brand name for your product? Giving you 20 seconds. There are 2 questions. In the meantime, I'll deal with it. One is asked by Tanmay Bank, if I'm pronouncing it correctly. Is notarization is a part of IPR? No. There is no notarization. Okay. Everything is done in black and white. You submit your details to patent office and patent office examines it. Okay. Second question is there, which is given by Prathamesh Deshpande. Sir, what is mean by plant patent? So plant patents are those patents which are given for new kind of a plant. That plant can be of flower plant or can be of new type of vegetable. If you have got any kind of new seed and you created something new out of the existing seeds, and let's say you created some invention and you got a new kind of a flower. So where are you going to file it for IPR? So since it is a plant, you can file it under Plant Patent Act. Okay. Okay. You know, these symbols and these designs, they take a lot of time, 3 months, 6 months, sometime a year to come up with the name. Okay. Recently, if you look at Google, when they started their AI in competition with ChatGPT, what was their name when they come up? they come up with the name Google Bard. Correct? Letter words that they convert that thing into Google Gemini. You know, every single name, every single brand name, every single logo, it takes time for industry to design it. Because most of the people, they recognize by seeing the visual. They recognize your product by seeing the visual. You want that visual to be protected under the act. Let's see, I'll make one action. Two hands like this and एक दिया जल रहा है इसमें. Two hands like this and एक small सा दिया जल रहा है. कौन सी कंपनी का नाम आपके दिमाग में आता है? Giving you 20 seconds. Write in the chat box only. Okay, Anil Manekar said LIC. Okay, Achal Kumari, same answer. Okay, last 10 seconds. Nalini Tripathi, LIC, correct. Okay. Okay. So this is the logo of LIC. This is been trademarked or this is registered under trademark so that nobody can use it. We have a visual effect. The thing which we see, we recognize it. Now, just to clarify the basic concept, there are generic products and there are branded products. Most of you might be knowing the difference between these two things, but I'll make it clear so that we can go for this trademark kind of a thing. Generic product. Let's say you went to a shop and you said कि भैया 2 kilo शक्कर देना. So this shakkar which you are taking loose in a poly bag, it is known as generic product. The moment you say कि भैया 2 किलो शक्कर XYZ कंपनी की देना, XYZ कंपनी की पैकिंग में 2 किलो शक्कर देना, it become a branded product. Okay, your brand can be created if there is any brand name and there is any logo or there is any slogan or there is any specific shape, color, size to it. If you want to protect it, what you need to do? You need to go for trademark. If you get the trademark, nobody else can use it. अभी देखो, 2 दूध के ग्लास एक पर्टिकुलर चॉकलेट के हिस्से पे गिर रहे हैं. This symbol, what does this symbol depicts? This symbol depicts that the chocolate which you are eating is having milk. Milk is considered good for the health. So this symbol is expressing that you are eating a chocolate which is good for health. Everything is symbolic. What trademarks does? They protect that symbol for you. Nobody else is going to use that because you have got the trademark for it. Okay, are you getting this point that your visuals which you have created, either it is logo, either it is design, either it is shape, or it is a slogan. जैसे एक slogan है ना, जो बीवी से करे प्यार वो प्रेस्टीज से कैसे करे इनकार. All these things are making your product unique and you want that product to be protected. You know, Windows का symbol जो Microsoft का सदियों से चला आ रहा है, it is unique. We identify Microsoft with that symbol. Intel Inside, we identify them with that symbol. Mercedes-Benz, they have got a very specific symbol and that is why they are unique. We are identifying that brand, we are identifying that company because of those symbols, and you need to have the trademark for that. What are the advantages for such kind of trademark? If your startup gets it, it can create monopoly for your product. There is no time limitation. if renewed, and if you use it correctly, this property, this trademark can be traded. You can sell it. You have got the logo under the IPR Act, and you can sell the logo to somebody else. Lot of benefit can be drawn if the trademarks are there. Disadvantages can be lost if it becomes generic. Trademark is a weak protection as compared to patents. Okay. Now, industrial design, or a kind of design which is used for industry, it is same like the design patent, wherein you create something very useful for industry. Look at this chair. This is patented under industrial design. This new kind of a bike, patented under the industrial design. New kind of juice maker, patented under industrial design. Advantage, it prevents unauthorized copying from the original design. Disadvantage, ensure registration before disclosure, because otherwise these designs can be stolen. Okay. Geographical indications, as I told you, to protect the culture, heritage, and uniqueness of a particular geography, the government has come up with these geographical indications. If a particular region is known for something, so जैसे नागपुर का एग्जांपल दिया था, नागपुर is known for oranges. So they've got geographical indications as a patent or as an IPR with them. So only they can use it. That specific oranges or a specific kind of process which has been utilized to grow those oranges may not be used by somebody else. Those oranges are unique, and products based on those oranges has to be in line with IPR. They have to take proper permission from the government so that the uniqueness of that geography can be maintained. चलिए आगे बढ़ते हैं. Plant variety we have discussed. Trade secrets. Okay, trade secrets. Okay. Anyone knows the formula of Coca-Cola? How Coca-Cola manufactures Coca-Cola? What are the exact ingredients? What is the process to make Coca-Cola? Nobody in the world knows it. Nobody world in the knows it. You go to the Google, you search everything, and you'll find there is no details regarding Coca-Cola, how it is manufactured, how Pepsi manufacture their Pepsi. They write the contents. What are the contents? But what is the process of making that Coca-Cola or Pepsi? They do not write. Why? It is a trade secret for them. Why people are keeping trade secret? They want advantage. They want monopoly. अगर आपको अपने प्रोडक्ट का यूनिकनेस बरकरार रखना है तो आप चाहते हो कि कोई भी आपके जैसा प्रोडक्ट ना बनाए, तो व्हाट यू नीड टू डू? You need to secure your formula with which you are manufacturing something. You need to secure your formula with trade secret, one of the kind of IPR. File under trade secret, and there will be protection by Government of India so that nobody else can use that trade secret. Any kind of trade secret, you can protect it under this thing, such as formula, such as processes, such as customer list, which you are using for your businesses, that can be protected under trade secrets. Again, unlike patent, trade secrets do not require formal registration and can provide indefinite protection. In India, trade secrets are protected under Common Law Principles and Information Technology Act. Okay. What is the uniqueness or advantage of trade secret? It protects confidential information. Now, when these trade secrets IPR are useful, let's say, for example, You have got some trade secret, and one of your employee, when he was working with you, he came to know about your trade secret. The moment he left your organization, what he did, he went to your competitor and he disclosed that trade secret. In that case, your company will be under a big loss if your competitor knows your trade secret. So, to get it protected, you can sue that employee and the company for disclosing and using the trade secret. Okay, and that compensation the court can give, it can be to the extent of the losses or notional losses which can be predicted. Nobody would like to mess with the IPR laws in real world. No good company, no big company will ever do the copyright violation, patent violation, or trade secret violation knowingly, because they know the penalties are huge, and the company or the person which is breaking it can go bankrupt if they lose the court case. Competitive differentiation can be created with the trade secret, and if you want to sell that trade secret to some person, to your partner, to anyone, you can give the license to that company to the extent possible. Only that company will be using your trade secret, and for that also you will be getting royalties. Okay, now we are coming down to the last part of our session. Being a startup, how can you develop your business using IPRs? Should there be any strategy? Yes. See, you all know that IPR can give you what? It can give you competitive advantage, because you got unique product or process which others cannot use without your permission. So it is giving you competitive advantage. You have got the product which others are not having. You got the product which people want, which customer want, but only you are in a position to supply it. Nobody else, no other industry can supply it to anybody else. Then valuation funding with IPR, you can increase the valuation of your fund, valuation of your company, and you can generate the funds. Commercialization and monetization and market expansion, all these are the benefits and importance of IPR. Look at the Indian landscape at first, and then we can see the IPR strategy. India ranks 40th out of 132 countries in 2002 Global Innovative Index. So what does it mean? We Indians are innovative. Undoubtedly, we Indians are innovative. We have filed more than 1 lakh patents last year. We are innovative. But still we stand at 40 number out of 132 country when it comes to Global Innovative Index of 2022. India have increased its trademark registration by 50% in last decade. It shows that more number of startups, they are getting themselves aware with the trademarks and getting their logo, getting their tagline, getting their specific shape registered under Trademark Act. India is also running very high on design registration. It is also running very high on commercialization of their intellectual property rights. In fact, some of the companies, they have made it a business that they create some IPR and then they sell it to some other company and they get royalty out of it or one-time payment out of it. Now, if you are a startup, what should be the strategy you should use to grow your business? Number one, identify your key intellectual property. See, intellectual property rights means you'll be filing for rights of that intellectual property letterwords. But first thing, identify the most valuable intellectual asset you are having. It can be your process. It can be the way you are serving that product. A lot of restaurants, they have uniqueness in terms of their product making. They can go for that patent, or that they can go for any kind of IPR and secure themselves. Any startup, when you are launching your product or when you are starting your business, think about it. What is the intellectual asset which is making your product or your services different than others? Identify it. The moment you identify it, write it down in your own words. Be very honest to the extent possible. Write all the details to the extent possible. Okay. Then go for filing of that intellectual property or intellectual asset which you have thought of that is most valuable intellectual asset in your business. Think about it. Do you want to have the copyright, or would you like to have the patent, or is it coming under the design? The choice comes, and choice is decided based on the kind of thing. If there is a product, so you need to go for patent. If you've written a kind of manual for something, it can go for copyright. If the manual consists of some processes, it can go for patent also. Once you file for IP rights, wait till you get the IP rights or intellectual property rights. The moment you get it, now is the time to go for utilization of your intellectual property for more innovation or for more revenue or for boosting the valuation of your firm. Most of the companies or most of the startups in India, what they are doing, once they do some innovation, they check it thoroughly, they get the IP, intellectual property rights for that, and then they ask other companies to purchase it from them. Now, purchase can be done in two ways. Way number one, there can be one-time cost that एक बार में इतना पैसा दे दो and take this IPR. This IPR will be now belonging to you. We will be having one mutual agreement, mutual contract, wherein I am transferring all my rights to you and you pay me lump sum amount at once. Or it can be like कि every time or every month, if the company is making sale of, let's say, 1 crore, so out of that 1 crore, 2%, 3%, 5%, 10%, 20%, whatever they mutually decide, that amount can be paid to the original inventor as a royalty. If you want to use any of these two strategy, you're okay. Or third strategy, if you feel that your invention for which you have got intellectual property right is very useful and you are passionate to produce it, or if you wanted to convert that thing into business, you can go for it because it is your intellectual property rights and you are legally protected for it. I am going to repeat this thing because it is worth repeating. Number one, identify your key intellectual property. In your business, what is your key intellectual property? What is unique intellectual property? The moment you identify this, then go for second step, filing for copyright. Sorry, filing for intellectual property rights. Number three, wait for it. The moment you receive it, go for leveraging. Leveraging can be done in a three-way, more innovation. Number two, selling it to third party, either with one-time settlement or one-time payment, or by monthly or gradual royalty. And third thing, you can start or you can boost your own manufacturing and start doing business based on it. Remember these three things, these are important. Okay. In India, some startups, they got very good funding because of their innovations and because of their IP rights. Zoho, which is a company which is based on SaaS, software as a service. They have got 25 patents with them, and with their robust IP strategy, they are gaining a lot of momentum in India. Ola Electric is one of the same. They have got a lot of patents with them, and because of that, they are gaining momentum, and they have got a lot of funding with them in India. Now, while I have shown you all the rosy pictures of IPR, there are certain challenges, and they are real challenge. You know, limited IP awareness. I normally interact with on an average 4 to 5 industry people every week. So count it, let's say 200 industry people every year. Those who are either employee or employer. And out of them, only 10% they are having certain idea regarding intellectual property rights. Most of the startups, they are thoroughly involved in developing the product, but they forget about IP protections. So awareness is the first thing, which is the most challenging part. You remember I told you that please take the screenshot of one particular slide wherein all the PDFs are given, all the website addresses are given for all these IPRs. Guys, go to internet and try finding all these things in one slide. You won't find it. It took me some time, but I compiled it. Not hard to compile, but yes, it is a task. Now the thing is, if you read all those PDFs related to Copyright Act, Patent Act, Trademark Act, you will come to know what are the intricacies, what are the ins and outs of all these IPRs. In 2 hour session, I cannot teach you or I cannot tell you all the details. It is just a kind of a session which is motivating you, which is giving you enough hands-on information so that you can move ahead. But if you would like to make yourself thoroughly aware, thoroughly proficient with these laws, and would like to build your company's product or company's process based on that, go read them. Give yourself some time. Make yourself aware. Maximum Indian industries, they are not aware about it. Because what happens now? See, the biggest challenge for an industry fellow is कि माल बिकेगा कैसे? How can I sell my product? So he or she mostly focuses on that thing only. कि product बिकेगा कैसे? IPR is a long-term strategy. So unless you are aware, you'll not be going for it. So awareness is the first biggest challenge, which you as an individual, you as an industry fellow will be facing. But simple solution, read those laws, very easy to read, very easy to understand, that give you some time. Okay. Next thing is the funding constraints. Lot of IPRs, they need time. They need funds. Vaccine, as I give you the example, it was not created out of some 1-2 lakh rupees. Required huge amount of investment. From where are you going to get the investment? Once you create something new, once it is working in the market, the investor comes to you and they would like to invest in your product. But before you convert your idea into a kind of viable product or viable process, nobody would like to fund you. I won't say nobody, but very few people would like to fund you. So that is a real challenge. So one of the solutions for this real challenge is angel brokers, private equity funds, and nowadays crowdfunding is also one of the good option for you. Then enforcement challenge. In developed countries, the IP laws are follows with word and spirit. In India, though the situation is not exactly the same, we have got protection, but yes, legal hassles are there. If in USA you get this court settlement within 6 months, in India it will take you around 2 years. So the time required to get justice is huge, and we are a country wherein getting this law enforced on small businesses, very small businesses, let's say small scale businesses, it is very difficult. So I remember I visited one of the marketplace in Amravati, which is a part of Maharashtra near Nagpur. So I saw there was one hart, yani ki bazaar was going on, one small hart was going on. And I saw a biscuit packet, which was exactly looking like Parle G. When I read it closely, it was not PRALE, it was PARLA, Parla G. The another packing, the remaining packing and everything was same. In India, it is difficult. But yes, the production is there. You need to be aware. Then global competitiveness. Indians are very late nowadays in filing IPRs. In most of the developed countries like USA, in European countries, in Australia, New Zealand, you'll find the moment somebody go for the startup, they initially go for filing the IPR. Because of that, most of the companies, most of the Indian companies, they face it very challenging to deal with the global competitiveness. Most of our inventions which we are thinking about, somebody has already done it. So it becomes very challenging for us. But the solution is whatever has been done in that area, believe me, you can add some value. Believe me, you can add some value. If you just think innovatively, you can add some value. I, for one, normally when I lack some idea or there is some writer's block while generating the idea, I used to play with my kid. Right now he's 13-year-old, but when I play with him, I find that he's innovative. When you play with your 5-year-old son, grandson, or some nephew, do spend some time with him. He'll give you some innovative ideas, not by words, but by the actions. Okay. So, is there any support for IPR in India? Is there any ecosystem? Yes, there is ecosystem. Government has taken a lot of initiatives. National Intellectual Property Right Policy is there. You can search it on Google and you can use it. Then the startup incubators are there in India. These startup incubators like IIT Bombay, they have got startup incubators also. They'll provide you all the details related to your ideas, how you can convert this idea into product and how you can secure this idea by converting into product and by filing for IPR. They will guide you. Not only IIT Bombay, most of the good colleges, they have got incubation center wherein not only the college student but the rest of the world can come up and can be incubated. So let's say, for example, in Symbiosis, right now we are in process of starting, but once it will be there, the common person, any startup of India can come up and can bring forward his idea or his business plan in front of us. If it is suitable, that will be definitely considered for incubating, or while incubating, the IP process will be informed, will be guided to that startup. Then third, IP Facilitation Center. There is Department of Industrial Policy and Promotion, which is known as DIPP. They have set the IP Facilitation Center across country, and any small scale industry, medium scale industry, any startup, they can approach them and they can get further assistance from them. Of course, knowledge will be given, fund you will have to create by your own. And then there is body called NIPM, National Intellectual Property Awareness Mission, which is providing online as well as offline program on IP awareness. Okay. So now some time for some facts and figures. The startup valuation by 2020, startup IP valuation by 2027, it is estimated that it will be around $3.6 billion. Those startup in India which have got intellectual property rights with them, they expect 20% royalty on an average for their innovation. That is a huge sum. And startups that are effectively monetize their IP can generate up to 45% of their total revenue from licensing, franchising, and other IP-based strategies. So licensing means giving license to others. Franchising means opening franchises of your product, services, or brand in different cities. Of course, you don't open franchisee by your own. You invite public interest, and then you give them authority to sell your product. Okay. Licensing agreement. For example, if you would like to go for intellectual property licensing and collaboration opportunities, there are certain steps. Number one, licensing agreement you need to prepare. Do not go for any kind of agreement, any kind of business by using your IPR unless there is a specific agreement. Those agreement must be notarized. Agreements between two parties or two or more parties must be notarized. And cross licensing. Now, cross licensing is a kind of a process wherein 2 or 3 startup or 4 startup they come together with their IPs. Let's say company 1, 2, 3, 4. So company 1 has got 2 IPRs, company 2 has got 3 IPRs, company 3 has got 2 IPRs. So all these companies will come together for creation of a new business or for taking benefits of each other's IPR for mutual growth. And then the third thing, that is strategic partnership with large corporates. So let's say, for example, you are a small startup and you have created one component which can be used in Mercedes. Okay. So you can go to Mercedes, share them ki you have got some component with you for which you hold the IPR, and that can be useful for Mercedes. Let's say it can enhance value of Mercedes, it can create some more value addition in Mercedes, can reduce cost, or can give some more features. So you can contact them, you can ask them, okay, I would like to have this strategic partnership with you. My company will be manufacturing this thing for you, and you will be giving the exclusive contract to us for this particular kind of a tool. Okay. IP and its future in India. It's I can say that those companies, those startups which are going for intellectual property and they are getting intellectual property rights with them, they have better chance to get success than those who are not having those IPRs. Some of the numbers, as I told you, you can look at them. You will be amazed to know that China in 2022 they have filed for 16,19,000 patents. US number 2, 5,94,000. India 77,068 in 2022. But again, if you look at the arrow, before a year in 2021 they have less. In 2022 to 2022 they have progressed by 25.3%. So that means more 25.2% more patents were filed in between 2021 to 2022. Then we have got another figure, global IP filing activity in 2022, patents in globe, that is in the entire world, 3.5 million patents were filed in 2022. Utility models or utility patents, 3 million, that is 1 million is equal to 10 lakh. So 35 lakh patents, 30 lakhs utility patents, and trademarks, 15.5 millions, and industrial design, 1.5 million. Again, China is leading in all areas in IPR filing. Okay. Now, I would like to close this session with few facts and figures. I just wanted to highlight the importance of this facts and figures for the world, that patent is important. you cannot say that ki without patent you can survive in the real world. No, difficult. Panasonic, they have got approximately 94,337 patents families with them. Samsung, 84,661. Huawei, 76,801 patent. LG Corporation, 69,412. IBM, 47,130 patents. And guys, these are just not static numbers, these are progressive numbers. They are increasing each year. So if these big companies are going for patents, you can easily imagine what is the importance of patent. Just to update your knowledge, giving you few briefs about what is the historical context of patent filing. The ancient traders from China, Egypt, and India, they used to have their logos which distinguish their product. The Venetian law of 1474, it was the first system to protecting invention by the form of patent. In 16th century, Tudor England, the Statute of Monopolies in 1624 was the first written law provided for the grant of monopoly for an invention for a limited period of time. So 1624 was the first time when monopoly for invention was officially registered. In France, 1791, and in USA, 1788, this system was used. Just to update your knowledge, Indian patent system, it is really robust nowadays. It started in 1856, and there are a lot of amendments which has been done. So guys, this is all from my side. I'm keeping this session open for, let's say I have got 5 minutes with me. So session is open for 5 minutes. If you've got any query, either you can unmute yourself and speak, or you can type it in the chat box. What we have seen today, we have seen what are IPR, intellectual property rights, which are basically the property of our intellectual. We have seen various kind of IPRs like patent, copyright, trademarks, geographical indent, industrial design, and so on. We have also seen the importance of IPR for the India, and at the same time for the startups which are running in India. If a startup uses IPR, their revenue increases by 49%, and normally 20% royalty they can expect from their intellectual property rights. And we have also seen that if you want to grow your business in a startup area, go for IPR. First step, innovate something new. Step number 2, file it for IPR. Step number 3, once you receive the IPR, go for commercialization, go for further innovation, or go for expansion of your business as per your choice. Okay, Sunita ma'am, I'm done from my side. It is over.
Thank you so much, sir. Participants, if you have any question, as sir said, you can unmute yourself or you can please type in a chat box.
एक Satyamurthy Vamanan, he has asked one question. As an employee, I create an invention not related to my organization. Can I patent it? To give you the direct answer, if the invention is not related to your organization, and if you have not used the resources available in organization, then you can go for patenting of it. Okay. But if you have used any resources of your organization while you created that patent or invention, you need to take no objection certificate from your organization before filing the patent.
Thank you very much, sir. That was nice.
Thank you, sir.
And it was a wonderful session. Thank you.
Thank you, sir. Thank you so much. Deboshri Roy has said, orange color evokes feel of energy and excitement, is create booster of human appetite. That's why business idea use this color. Okay, he has stated that thing. Business idea uses orange color because it energizes and excites people. You're right. Color has an effect on our mind. Na? That's why when we buy home or when we create home, we select proper color which suits to our mood or our aesthetic or our belief system. You know, when Hitler was gaining popularity in Germany, and when he became rural, he asked that maximum thing should be of red color. Why red color? Because red colors symbolizes anger, heat, passion, and so on and so forth. Color has a magic. And if you are manufacturing any product and if you have not got any logo or tagline with you, do create it, guys. Because it will give advantage, it will give uniqueness. I can see no further question. Achha, what is minimum plant notarized TK or a poem TK? Okay, Prathmesh Deshpande has asked what is meant by strategic partnership. Now, strategic partnership means a partnership between two or more firms. Let's say, for example, as I given the example, I have created some tool which is useful for a car manufacturing company. Let's say Mercedes, let's say Maruti, let's say Hero Honda. I created one tool which is useful for Hero Honda. So I am not going to create the Hero Honda entire bite. What I can do, I can approach Hero Honda or I can approach Honda, not Hero Honda, they have split. So I can approach Honda and can let them know that I have got certain tool which can make your bike more faster, more economical, more cheaper, or can add certain value. So if you want to buy it from me, I'll be able to sell it to you, either the design or the component. It can be done one-time lump sum basis, or it can be done on weekly or and monthly or annual royalty basis. So when two or more company comes together for betterment of the business using the IPR, it is known as strategic partnership. That's it, guys. Okay. Chalo. Thank you, ma'am.
Such a wonderful session, sir. Thank you, Dr. Shailesh, for that enlightening session. What an energy actually you are having. Your insights have truly enriched our understanding of intellectual property right and the significance in the startup ecosystem. Thank you all participants for your active engagement and thoughtful questions. We hope found this session informative and valuable for you. Once again, thank you, Dr. Shailesh, and thank you everyone who have joined us today. We look forward to seeing you at our future IIC sessions too in this great participation. Have a great day ahead.
Thank you, ma'am.
Thank you.